Chairman Welch has House Bill 814, which is a substitute. Mr. Chairman, if I understand this bill, it simply does two things. The business court is now going to be not attached to the Court of Appeals, but its own separate line item in the budget, I think. And then also there was an addition made to that last year. Of course, all of you remember there are many things our business court cannot do. One of the things in the conference committee that they were not here agreed upon was receiverships. Basically what I very novel, as much a novice, call state bankruptcies. And that was left out of the conference committee report last year, but it is in this bill for that purpose. So, Mr. Chairman, that is what I see that to be, but why don't you set us all straight, because I'm sure I didn't get it right.
No, sir, you got it right. That is it. The initial bill as filed just was a budgetary cleanup under the Budget Act. We have to designate budget units. And this was attached to the Court of Appeals in Chairman F. Stration's legislation. And that was to move it through and have a placeholder for it for this budgetary cycle. Now that we're here, we have the opportunity to separate that and give it its own section within our budget. And so we're moving it out of the Court of Appeals so that we be independent. Now, mind you, this makes logical sense also because the appeals from business court will go to the Court of Appeals or possibly the Supreme Court. So I think it is both prudent from a transparency and non-conflict perspective in the budget to have those separated. So that is the request that you have before you. In addition, that's Section 2 of the bill. Section 1 of this substitute is added to reflect the change in the legislation that did not make it through the process of conference committee, so that appointment of receivers would not be an area that the business courts could interact in. And that is the sum of the changes.
Senators say it's the House conferee's fault. I'm sure it's the senator's fault. What do you want to add, Mr. Abstration?
I just wanted to confirm what was said. And looking back at the timeline, we didn't know the posture of the business court bill, so administrative attachment was appropriate at the time, and this cleans up that issue. Also, we had a conference committee report that had many components to it, and ultimately similar language was passed in a different bill. So the conference committee bill wasn't ultimately passed, but all parties agree that this is a cleanup matter that needs to be addressed. So I just support the bill. Thank you.
Ms. Oliver.
I can't think of any reason, for any budgetary reasons, that this assigned to the Court of Appeals matters. I mean, the business court then will go directly to your committee. So that's the way it has been, and that hasn't changed. Am I correct about this?
Yes, Representative. It is currently under the committee as being assigned to the Court of Appeals. Mm-hmm. It will still be a part of that public safety subcommittee and appropriations, but it will be its own section.
Okay.
That's all that will change.
I want to follow up about the receivership. I heard about this as an amendment that was made in the Senate, and it was a little bit of controversy about it, at least what I heard. I wasn't there in the room. I was on the conference committee and probably made this mistake myself, but I don't remember having a discussion about receivership last year. I've served as receiver just a couple of times, but there's some lawyers that do this full time. And it's small matters and big matters, both. And I'm concerned if we're sending a lot of small business matters, because this doesn't have well, tell me this, does this have a dollar definition to it at all?
I don't know that, I think you have big receiverships and small receiverships, right, to put it in very technical terms. Mm-hmm. So no, right. I think you're right. You could probably have a big one, but my suspicion is that the biggest ones may end up in bankruptcy court, but that's me speaking.
No,
you've done it, you tell us.
Yeah, I have been appointed receiver when for certain properties out of Superior Court when there simply was a mess that nobody could clean up in terms of selling properties. But I'm just curious about where this came from in the Senate, because I want to be mindful of
in answer to that question, in the conference committee, it was Senator Kennedy that spoke about it a lot because he actually has some experience with receiverships.
That's his significant practice.
And my memory is that the now bankruptcy court, the now business court judge agreed, and I have spoke with him since then, and he says he doesn't think it belongs in business court. Once again, the comparison, as I understand it, the gold standard is Delaware, and as I understand it, that is not one of the things that they handle, and that's what we're trying to emulate. So,
Well, then I'm going to press my point then, if he agrees with me.
no, he doesn't agree with you. He agrees that he doesn't want it in business
He
court.
does or doesn't want it?
Does not.
No, well, I don't want it either.
Oh, okay. We're in agreement. I say.
Cases that can't,
Takes it out.
matters that can't come.
You need to tell me when we agree and when we disagree, and
I
then
know.
I'll be more quiet.
I'm confused here. I do, well, let me put it this way, because I
But
probably
this
messed
list
this up.
eliminates things from being in business court. Maybe that is what we need to
I
clarify.
do not want the business court to have jurisdiction over receivership cases.
Then that's what this does. Yeah.
Okay, and in the Senate, they allowed it to. So this is our House response to the Senate.
Actually, there was a separate bill that struck it, but we ended up passing. There was a Senate bill and a House bill competing. One of the bills that was not passed did appropriately eliminate receivership from being in the business court. The draft of what we passed did not, which I believe was an oversight.
So we're eliminating receivership from
You're
business court.
correct. That's right. All right. Mr. Dryer, I think you had yours pushed and I eliminated you by mistake.
Yeah, oh, no, thank you, Mr. Chair. And pardon me?
He's trying to eliminate me.
Well, and look, that's actually kind of the point I wanted to raise. I guess I'm kind of, my practice is not as extensive as Representative Oliver's and others, but I've had complex matters, and I would honestly kind of trust the business court. Sometimes courts don't want to take extraordinary relief, and sometimes it gets complicated, and sometimes that's necessary. But I don't have strong feelings. I just kind of wanted to weigh in on that point. So
He's
thank you,
not
Mr. Chair.
sure, but I think we could bring him around to our view.
Right.
Yeah, so,
No receiverships in business
all
court.
right. Mr. Abstration, anything else?
No.
All right. No one has signed up, or have they? Mr. Reed, come forward, please. Tell us who you are and who you're with, and we'd love to hear from you. I think I've turned on both of those mics for you.
Thanks, Chairman Fleming. Jordan Reed with Georgia Trial Lawyers Association, and this is Jason Rokes. And
Mr. Chairman, I'll just give a brief statement, and then Jordan has a few details. I want to make sure the full committee is aware that there is the conference committee report that was signed was brought to the Senate and is on the table currently waiting for a vote, which has single-party consent. And there's been discussions that, as opposed to the one that passed on day 40 with two-party consent, the list of issues that could be in front of this court with two-party consent was agreed to. If the conference committee report goes to one-party consent, we believe there's several types of cases that should therefore not be jurisdictional, as well as increasing the minimum amount for these disputes. And Mr. Reed has some more examples of that, but I want to make sure the posture today is that there's a conference committee report sitting on the table in the Senate waiting to be called for a vote that goes to one-party consent.
And it's been there for about 2 weeks.
Yes, sir.
Okay. And what does? It's been there for a year. Well, 2 weeks since they put it back on this session.
Right.
What does that have to do with us saying that the business court's not going to hear receiverships?
Because we would like this committee, if you're going to take business receiverships out, to add other types of cases also out at the same time.
Okay. Mr. Reed?
right, so when the two committee reports are going back and forth, when it was single-party consent, certain cases were taken out. When it's two-party consent, other cases don't necessarily need to get out because both parties have agreed to be there. So on the chance that there is going to be the single party consent, which is the way it looks like it could potentially go, and that these cases already shouldn't be in there, it is our hope that we could offer to the committee some language to consider to add to the list of cases that would not be eligible to be heard in front of the business court.
Mr. Welch?
A couple of things. One is, to be clear, what you're presenting is a discussion about a different bill in the Senate posture. So we're only considering my legislation to deal with House Bill 814. And I understand that it has that list in there, and I understand you want to weigh in on it, but I don't want to disturb this on a speculative outcome there. And because crossover is before us, I'd like to get this bill out and moved over to the Senate with the list that we have here and the striking of receivership, because I don't know if it's ever going to come back before us, whether it's single or double or two-party. I don't know. And I don't want to slow this one down because this is actually a necessary change to the Budget Act that avoids a conflict that I believe we have between these two courts. It was a necessary evil at the time to move it forward, but we're back here to make that, to correct that. And that was at the time we were assuming we didn't know whether the bill would even pass or be signed by the governor. So I hear you. And so I'm gonna ask a couple of things. One is I'd like the committee to move this bill forward as it is, but I do want to hear so that we know, because as it moves across, I'll be carrying this bill as it moves across. I'd like to know what the dollar amount is that the director mentioned, and I'd like to know the other items that you think should be removed if it goes to one-party consent.
Well, I'd like to say certainly, Mr. Chairman, under receiverships as number 10, we would ask number 11 condemnations, which are currently in the law, if that should be removed. Mass actions or class actions involving consumer claims or property claims, franchise agreements, and civil forfeiture. So there are some pretty serious jurisdictional matters that seem to me just as important as receivership that should come out of the jurisdiction of the business courts.
On the presumption that it changes to a one-party consent.
Well,
One or two party.
One or two party. By discussing the one party, that I was trying to provide clarity as to the discussion by Representative Oliver, and I'm sorry if that led to confusion. We're saying no, this is how the current law should be, and that's why we're advocating that the committee consider, in addition to receiverships, excluding condemnations, mass actions, franchise agreements, or civil forfeitures as well.
Ms. Oliver?
I'm going to evidence my confusion further. There were two conference committee reports on the last day of the session. The first one that we signed, we being the House signed, went over and the senators wouldn't sign it. And then
No, they did sign it, but they didn't vote on it.
there were let me start over. There are two conference committee reports that were floating around on day 40, and one of them passed.
Chairman Administration.
Thank you, Mr. Chairman. There was one conference committee report that was signed by all of the conferees. It was passed by the House and was not passed in the Senate. The Senate had a companion bill,
Right.
pending in the House. The House then amended the Senate bill. I'm sorry, that actually was amended in the Senate. I'm confused. That was my bill pending in the Senate, was amended with the language put on it, and the Senate passed it out. That was with the two-party consent, and then the House agreed to the Senate amendment. That's what happened.
Okay,
last year.
so we passed a bill on day 40 that required two-party consent.
That's correct.
Okay.
We actually passed both versions that day, but the one that ultimately was enacted was a two-party consent.
And on the conference committee table has never been voted on in the Senate on day 40 or the first 21 days of 2020.
That's
And
correct.
What we, in different views, are concerned about is that the Senate is going to pull that bill off the table and change the law of the land as we passed it in 2019.
Correct.
And then this bill comes in, parachutes in, appropriately so. I don't use that word pejoratively. I'm glad you're parachuting in on this issue. And these gentlemen want to open the discussion further along this line. So,
I'll agree with that, and maybe just add a comment. My understanding of the objective here today is to just correct an issue that has arisen from the conferees and the others who were present in the room as the deal was struck, as to an omission from the language that was discussed last year. You were also in the
but we
room.
agreed to two-party when we were, all of us in the room.
No, it was one party, is the conference committee report that
the House
everyone
passed.
signed.
It's on the Senate desk now.
Are we concerned in one way or another that the Senate, though, can pick up a conference committee report from 2019 that's on their table and pass it and change the law? We're concerned about that.
They can do that. It's
Yeah.
already been passed by the House, yes.
And we don't know what they're going to do because
We
we
don't.
don't know
It's
what.
been
We
sitting
don't.
over there for 2 weeks.
So
on
this
the
is
desk.
another way for us to re-energize ourselves in correcting at least one mistake.
It is a bill that deals with the business court.
Yeah, so you got other chances, gentlemen. Could go worse.
She's
though.
trying
It
to
could
tell
go
you
in
you
the
should be
wrong
in favor
direction.
of this bill passing now is what she's trying to tell
But
you.
I'm also telling you that it's gonna get worse.
Well, I would just respond that I think this committee should look at adding condemnations and mass actions, the mass torts, the franchise agreements, and the civil forfeitures, if with one or two party consent. That it's the same policy reasons that receivership should not be in there. And so we'd ask this committee to include those items as well. And it's better to do it now than try to do it later.
But you don't know if the Senate's going to pass that conference committee report.
We don't
But
know.
regardless if they pass that report or not, these should already be excluded from the business court.
What was the amount? You had mentioned an amount.
To the amount for damages requested for the amount in controversies. Currently, it's $1 million for claims not dealing with, for claims involving commercial real property, and $2 million for those that do not involve commercial real property. And we would change those numbers to $5 million and $2 million versus the $1 million and the $500,000.
Yes, ma'am.
Because I think Chairman Efstration can solve my confusion on this. I think that class actions were not submitted to the, tell me what the discussion was and the ultimate result on class actions, because that to me is different in this list that these gentlemen gave us. Class actions is different, in my view, than condemnation, franchise fee, and civil forfeiture.
I will just say that the list that's before you here, that's in law, and the one addition that's requested in Chairman Welch's substitute are my understanding of the deal that was negotiated last year.
For not being eligible for a business court.
Yes, ma'am.
That's what, that's consistent with my memory. But Mr. Welch does not want to has not said whether or not he's interested in including these 4 items. But he implies that he is, because he's offered a bill with only 1 item.
Well, I'll take that as a question to me. So as the author of the bill, the sponsor, my bill is section 2. So to be clear, but I am agreeing to making this correction as we move forward. And my ask is that we just pass these corrections. So and this is the first discussion I have heard from either of the 2 gentlemen in front of me concerning any of these additions. So I haven't had a chance to vet whether or not these make sense from a legal perspective, a jurisdictional perspective, or otherwise. And the corrections that I'm asking you to make, I have vetted with Mr. Davis, who is the purported judge of the business court, subject to being sworn in. So I can't speak to any of these issues without having him speak, and he's not on any notice that we would be considering anything beyond this. So I don't think it would be right for us to amend this bill without having some information from those that are interested in that court and how it functions. So I would not want to change the bill. Now, if that goes through a committee process and it gets to the Senate and the Senate wants to discuss it further, then I'll be happy to talk that through. But this is the first I'm hearing of this.
Would it be appropriate to hold until we have that discussion? I don't want to, I'm not suggesting that pattern. I'm just considering an option here.
I don't have. We have some time, so I'm open to holding it, and we can discuss it further. I'm also open to moving it on.
Mr. Walensky?
Thank you, Chair. Obviously, it's my second session, so my understanding from what I'm hearing is that the Senate right now has the ability to just change it to one-party consent, and the House will not hear it again. And the one thing I do remember last year is we spent at least 20, 30 minutes talking about how many parties, and that may not be relevant to the discussion today, but I just wanted to make sure that I'm correctly understanding the situation.
Mr. Dreyer?
Thank you, Mr. Chair. To echo what Representative Walensky said, being on one of the subcommittees that actually discussed this 2-party thing, we spent a long time both in and out of the halls, and a lot of us, I think, pledged our vote for it because we thought both parties could have consent, which made a big difference. In fact, I think there was a lot of discussion about if 2 parties can consent, we don't have to worry about a little guy, a regular citizen, getting hauled off to business court, and it being anywhere unfair. So that's at least how I remember the discussion. That was what I based my vote on. And I do want to say Chairman Welch, thank you for at least being open to consider this a little longer. It would make me more comfortable. And look, and the business court's in place. I think this is absolutely necessary. But sure would be nice just to get it right, if we could.
Well, tell me what's wrong with this bill, and then we'll get it right.
Well, I don't think it's anything wrong with this bill. I've never
Okay.
seen Chairman Welch do anything wrong. But
That makes two of us.
right.
Makes two of us.
I think that's fair. I'll retract that statement. But again, I think this is fine. I think that having such a wild card open to protect our back in the House on a priority for us, it would be nice to be able to get this as good as possible.
So, but I think the question I have for the members is that what these gentlemen have done is opened up a new discussion, but the bill itself and the change here is needed. I mean, what we're doing is we're going to hold something good. If they can make their case, and let's say things change, then I'm going to be open to talking with them on the Senate side about what changes might need to be made on this. But I don't want to lose it. I mean, I don't want to lose it to crossover and not make the change here. So I guess what I'm getting at, the bottom line is what I'm getting at. We agree the receivership should be eliminated. We also agree, we also agree that the court should have its separate section and not be attached to an appellate court that would be receiving its decisions from a budgetary standpoint. That creates tension between those two courts unnecessarily. It already exists. So, I mean, I would urge that I would rather us go ahead and move this along, but, I'm subject to the will of the committee because it has to move with the motion and pass. I certainly don't want it to fail. But understand this, so far what I've heard is that there's no problems with Section 1 and there's no problems with Section 2 as it is written. The question is who wants to amend it to open up these other areas? And I would prefer to, and we're doing that on the speculation that the Senate might do something we disagree with, which still has to be voted on by the House anyway.
The House won't be voting.
Ms.
On
Oliver,
the conference?
the House already voted on it, or approved it. Ms. Oliver.
What's making me nervous is about this procedural history that gives certain powers to the Senate that I'm not going to have a chance to review. And I'm also concerned about the Senate's action that has changed something in the last 24 hours. I personally don't want this business court to have class actions. But we can have that discussion today without the benefit of talking to Judge Davis, or if depending on whether somebody would like to offer an amendment, or we can hold the bill for a couple of days. I'm concerned about a chess game going on here that I'm not going to have another chance to participate in.
What happens then if I'm sorry, Mr. Chairman.
Go ahead.
What happens then if the Senate waits to make that decision
After crossover.
after crossover?
This bill dies.
That could be a problem.
So-
1 or 2 days might give us a fuller discussion about what we want to do about class action.
Mr. Demonstration.
Thank you, Mr. Chairman. I respect Representative Oliver's perspective on this. I certainly understand her point. I guess the mindset that I come before you all today with this, and this is having worked on this business court issue for 3 years and really spent a great deal of time, and I swore to myself and told many of the folks in this room that I wasn't working on any more business court bills, and here look at me saying what I'm about to say. My perspective is that what we have here is just making things right from last year, and that's in the sense of the administrative attachment was done because we didn't know if it would pass on day 40 or be signed, and the receivership issue, excluding it, which you apparently agree to, is just, frankly, just an issue as to the conference report, the agreement not being reflected in the conference report. So my request for for the committee's consideration is to pass this bill as is so that we can get it across. But I share the concern that that you're expressing, and I will just say I share the concern that's being expressed by the witnesses here today. Having worked on this several years, like I have, I think I have some degree of credibility on this issue as to business courts, and people care how I feel about it. And so my commitment is to continue to work on this issue, to work to address any concerns, to ensure that we don't have subject matters captured, and that the amount of controversy isn't to a point where certainly the legislature didn't intend it to be, or maybe more importantly, due to subsequent actions by the Senate, we now have a new situation in place. And so so I just want to extend that commitment to the committee if you're willing to support Chairman Welch's bill and the committee substitute to that bill here today. Thank you.
Mr. Bruce?
I just have a procedural question.
Yes, sir.
Because what I'm hearing is that there are some amendments that we want to make to this so that when it goes to the Senate, it goes the way we want it, as opposed to counting on the Senate to do what we want them to do and have it come back. Is that correct?
Yes, sir, and the question, the further is whether we do that amendment today or whether we do it tomorrow, Thursday.
Yeah, so procedurally, can we just delay this for, towards the end of this meeting, let the people go ahead and work on whatever the amendment is, and then just take it back up at the end of this meeting?
Procedurally, if the committee voted to do that, we could do that, yes.
Okay. Can I make a motion that we do that?
Not yet, because some of your colleagues want to talk.
Oh, okay.
First time I've ever known this group want to talk a bunch, but there's still a few, but we'll come back to you.
Okay.
All right. Ms. Silcox.
Thank you, Mr. Chairman. I think particularly in light of the fact that this is already law, and the governor's already signed on this, and the court is already operating, I think it's really important that we clarify the jurisdiction of the court, and we we decide on the matter before us. I think that any bill that's proposed is always up for speculation in terms of what the Senate's going to do. I think it's important that we go ahead and decide it, and I'd like to make a motion to pass at the appropriate time.
All right, we got two of you that want to make motions. We'll come back to that in a second, but I'm going to let last person, Mr. Wilson. Is that you?
Thank you, Mr. Chairman. I have a parliamentary question.
Go ahead.
What's the absolute latest that we could pass this and it still have enough time to get across the building?
How many angels can dance upon the head of a pin?
Right.
Do
we have through the end of this week?
It is speculation. The answer is, technically speaking, if the Rules Committee chairman, if the Judiciary Committee chairman called a meeting on crossover day, and the Rules Committee chairman called a meeting after that, sufficiently after that, then technically the Rules Committee chairman could put it on crossover day. That's how the House rules differ from the Senate rules. We can do things kind of at the last minute. However, the other side of that is that the longer you wait, the less likely it happens. The opportunity for the underlying bill to pass goes down. I'm sorry I can't give you a better answer than that, but I think I told you the truth.
I think you did. I appreciate that. And at the appropriate time, I'd have a motion.
Absolutely. All right. The chair has 3 people that want to make a motion. And the chair is going to defer to the author of the bill for his motion first. And if you don't like his motion, then you need to defeat it, and we'll move to other motions. Mr. Welch.
Mr. Chairman, I would like to move that we move to pass on this and not leave it to the Senate to speculate on what I think are good, legitimate legislative priorities for this measure.
All right, there is a do pass motion. Is there a second? Second. All right, there's a motion and a second. Now, Mr. Bruce, and Ms. Silcox, and Mr. Wilson, in order to get to your motion, this motion on the table would need to be defeated. Okay? So now there is discussion on the motion before us. Absolutely.
My motion would be a motion to table. Would that not take precedence over the motion do pass?
If there was not a motion on the table, it would. But when there's a motion on the table, that motion has to be disposed of before we go to another motion. Ms. Oliver is whispering to you. You want to ask the clerk question?
Mr. Chairman, when can we entertain amendments to the motion?
I'm sorry.
Given that there's a motion pending.
Now would be the appropriate time to make an amendment.
Okay.
Yeah.
Well, at this time, then I would move that we amend this bill to include the language that the gentleman had brought before us.
Now you're gonna need to give us that language. Mr. Wilson.
Okay.
It's gonna be probably close to it. You probably need just the last page.
All right, Mr. Chairman, let's see here.
If you want to delete, if you want to add things to this list, which would in turn take things away from the business court, you probably would want to start by
Yes.
calling one number 11.
I'm looking at line on
Probably line 27. You want to insert between line 27 and line 28 is what you want to do, I believe.
Yes.
But you just got to tell us what you want to call number 11, which would be the addition, I believe.
Okay. Number 11, Mr. Chairman, would be condemnations.
The
Under
word
that,
condemnations.
condemnations,
All right,
semicolon.
there's a motion to add condemnations. Is there a second?
Second.
Okay, discussion. Hearing none, the chair will.
Why, no, I'd like
Yeah,
to know
discussion,
why.
Mr.
I mean, you're just going to take a list that was just handed to you presently from lobbyists, and we're gonna vote on all those. I mean, I hear Oliver has and has always had an issue with mass tort or class actions, but I am gravely offended that this is how this is going to be conducted. I mean, so I would like to know the reasoning for every single one of these motions, and I want to know the legal basis for why we want to exclude these issues. So let's walk through each one of them, Chairman.
Any further discussion on the adding a number 11 in between 27 and 28, the word condemnations? Hearing none, the chair is going to call the question. All those in favor of Mr. Wilson's amendment, please indicate by saying aye.
Aye.
All those opposed?
No.
All right, chair is going to ask for a hand vote. All right, all those in favor of the amendment, please raise your hand. 8 yes, no's? 2. 1, 2, 3. You got your hand up, Judge?
Yeah, no, I did it first time.
Okay, all right. All right, that is added. You have another
Yes, Mr.
addition, okay?
Number 12, mass actions or class actions involving consumer claims or property claims, semicolon.
Second.
Yeah, repeat that, Mr. Wilson, please.
Yes, sir.
You got 2 copies of these lists?
No, sir.
All right.
But I'm happy to pass this down if it would be helpful.
Well, you need that one.
You need to pass it back.
Evan, will you make a copy of his list real quick for us, please? But you got this one memorized, so go ahead and tell me.
Number 12, mass actions or class actions involving consumer claims or property claims.
Consumer claims or property claims?
Yes, sir. Semicolon.
Property claims, semicolon. Okay, discussion. Ms. Silcox.
I think this is partially already covered under the exception number 8, as stated in the bill. Individual consumer claims involving retail customer of goods or services or user intends such goods for personal, family, or household purposes. So I think this is already at least partially covered. I don't think that amendment's necessary.
Ms. Oliver?
I think you can make an argument. It may be a decent argument that's partially covered, but I think we very much need to have specificity in terms of class or mass torts.
Any other discussion? Hearing none, the chair will call the question. All those in favor of what would be number 12, Please indicate by raising your right hand. Okay,
Mr. Chairman,
and all those opposed?
I'm opposing this.
1, 2, 3, 4. The chair votes no. There's a tie. It fails. Next amendment, which is going to be 12 now.
Mr. Chairman,
Yes, sir.
Can I ask for reconsideration? Sorry.
to reconsider, one of the members had to step out, so he wouldn't interrupt the meeting.
He missed the vote. He missed the vote.
Reconsider?
No. Do you have number 12?
Number 12, franchise.
Yeah.
Number 12, franchise agreements, semicolons.
All right. Discussion on what would be addition number 12, franchise agreements. All right. Hearing none. All those in favor, go ahead and raise your right hand. 6. All those opposed? 2, 3, 4. You don't count. I'm sorry. It passes 6-5. All right. Do you have another one, Mr. Wilson?
Yes, sir.
Mm-hmm.
Number 13,
Uh-huh.
civil forfeitures. Period.
I'm sorry. I didn't have your mic on. Civil forfeitures. Period.
I'm sorry. I'm sorry. I read that wrong. Civil forfeitures, semicolon.
Semicolon. Okay. All right. I haven't been asking for seconds because I know that you're in agreement with it, but let's go ahead and do it right. Is there a second?
Second.
There's a second. Any discussion? Seeing none, all those in favor, please indicate by raising your right hand. Almost missed it. 6. All right. All those opposed? 1, 2, 3, 4. 6-4. Passes. All right. Do you have another one, Mr. Wilson?
Yes, sir. This would be number 14, correct?
Yes, sir.
14, mass actions or class actions involving consumer claims or property claims, period.
Parliamentary inquiry.
Yes.
We've already voted on that exact amendment.
That's true. We have.
May we discuss his inquiry?
Sure.
It's not exactly what we voted on. Earlier we voted on the language, the number 1, the number 2, a parenthetical, mass actions or class actions involving consumer claims or property claims, semicolon. Now we're voting on the number 1, the number 4, parenthetical. It's different.
Tell me the difference between the two.
The precise language. One of the numerals.
Explain to me the difference between the two.
The order of the language is different.
I want to know the effective difference between the two.
Well, effectively, it would just change the order they're presented in this list.
Okay. Chair's going to rule that we've already voted on that.
Thank you, Mr. Chair.
Okay. Do you have another one, Mr. Wilson?
Yes, sir. Looking at
And I think this would be 14.
Yes. Yes.
Mr. Chairman, I call the question.
okay.
Well, I'm going to give him a chance if he has one more he wants to add, and I'm not going to cut him off.
Yes, sir.
Well, hold on a second. Mr. Wilson, do you have another one?
Yes, sir. Number 14,
Yes, sir.
class actions with an amount in controversy greater than $5 million.
Okay. Is there a second? Any discussion? Ms. Silcox?
Again, I think we've already at least partially covered this, that we've already voted on mass class actions.
You want to weigh in, Mr. Welch?
Yes, I think that we were doing a wholesale waive of that, and while there's a monetary amount, it still has the same effect of excluding class actions.
Agreed.
which would be the cause of action to be heard regardless of the amount.
Mr. Frustration?
So parliamentary inquiry, isn't it true that the conference committee specifically considered some of these subject matters, and that's why the language is reflected in number 8 herein, and whereas the condemnation, franchise agreement, civil forfeitures are new matters that are being added in that consistent with the conference committee report, this Fifth Amendment should be voted against by the committee.
So I think Ms. Silcox had a parliamentary inquiry, and she's asking the chair whether or not we've already voted on this amendment.
Oh,
And you just don't like the amendment, period, and you're asking your colleagues to vote against it.
that's right.
So, but to Ms. Silcox's question, the chair is going to rule that it is sufficiently different than what we voted on previously, and I'm going to allow the committee to vote on this amendment. That's class actions when the action in controversy is greater than $5 million. Did I state that correctly, Mr. Wilson?
You said, I'm sorry, can you say that one more time, Mr. Chairman?
Let me ask my expert scrivener right here. You say it for us. Yeah, turn that mic on.
It would be class actions with an amount in controversy greater than $5 million.
Is that right, Mr. Wilson? Okay. All right, so here's the posture. That addition is in the form of an amendment. Are you going to second that, Ms. Oliver?
Yes, sir, second.
Okay, there's a second. There's discussion on this amendment. Chairman Efstration already expressed his view. You want to talk some more, you can.
I'm not going to repeat what I've said earlier today. I think I have a degree of credibility on this issue. We want to make sure we get this issue right. We came into this today trying to correct issues from the conference committee last year, effectively. And this matter specifically, I think, was addressed in paragraph 8. So I've been with the proponents of these additions because we want to make sure that this court is appropriate and acts right. But out of deference to and concern for being consistent with the conference committee agreement from last year, that's the reason I'm opposed to this Fifth Amendment.
Ms. Silcox?
Thank you, Mr. Chairman. I guess in the spirit of the bill itself, the original bill, I would feel very strongly that the business court was specifically designed for more expensive, per se, more sophisticated cases. And to that end, if it's something that's over $5 million, I would respectfully say to the committee that it should definitely be in the business court.
Class actions, this would be excluded. Class actions when the amount in controversy is greater than $5 million. That's right. So you would be including class actions less than $5 million?
That wasn't the language that we've looked at. That I believe would be the effect of that language, is what you're saying. But I need to look at the rest of the code section to see how those mass actions and class actions would be included. Certain ones are already excluded, as Representative Silcox said, but in the totality of that code section, some are currently included that I do not think was potentially the intent of the committee when it was passed last year.
Well, Mr. Wilson, it's your amendment. You want to stick with it?
Yes, sir.
Okay. All right. Any other discussion? All those in favor of the amendment, please indicate by raising your hand. 2, 3, 4. Yes or no? 4, 5. All those opposed? 2, 3, 4, 5. The chair, 5-5 tie. The chair votes no. The amendment fails. Would have failed anyway because it's 5-5 tie. But I think it's worded wrongly. I don't think you worded it the way they wanted you to, but nonetheless.
Mr. Chairman, may I make a motion to table?
You need to defeat the motion that is on the table that is due pass. So if you want to make that motion, you need to defeat the current motion, which is on the table. Okay. All right. Any further amendments?
Yes.
Mr. Welch.
May I move that that we strike the amendments that have been proposed, and in lieu thereof that we add at line line 27, that we delete the S after action and delete the S after petitions.
Give me that motion one more time.
My motion is to strike the amendments that have been voted on thus far and further amend the bill at line 27 by deleting the S at actions and the S at petitions.
Well, the chair believes that your amendments to line 27 would be in order because we have not amended those areas. However, just as the chair ruled earlier that because we had already voted on something once that we were not going to re-vote, I think voting now to strike all those amendments would be simply re-voting on them. Now, if the chairman Welch wants to give me his wisdom, I'm willing to be persuaded. Maybe I've got that figured out wrong.
In following the rules as I understand them, the last motion on an amendment would surpass any of the other amendments. And so obviously my request here is in opposition to the amendments that are being proposed, and further making the clerical changes to that language. So if the chair wishes to rule me out of order in making that motion, I understand, but that is my motion.
Discussion, Mr. Chair.
Go ahead, Ms. Oliver, straighten us out.
I think we're doing some very important things here, and we're about to mess it up a little bit. And I want, at whatever appropriate time, to ask that this be tabled for a 24-hour period to be brought back, because I'm very respectful of how much insight, and as I'm sitting here, my memory is coming in and out about our discussion on class actions, and I don't like to be voting on things that I can't remember clearly. So I really think if we took 24 hours, we would be a happier group of people with a better product. Maybe. And I'm also concerned about the Senate really trying to understand what their strategy is here.
The question before, and we would get to a motion to table after we consider this. The question is before the chair now. Has Chairman Welch made a motion by striking the S's on line 27 after the word actions and petitions and everything else between there and line 28, which is all the amendments we just added? Is that a proper motion? He cleverly included that we strike the two S's to make it different and affect everything beyond it, rather than asking that we re-vote on the same amendments that we voted on again, as Mr. Bruce asked when Mr. Walensky left the room. Don't leave anymore. I'm giving you a hard time. I'm just trying to make light of a serious situation. I'll get up and leave in a minute too, don't worry. So the chair the chair is going to allow Mr. Welch's amendment, because I do not believe that he's asking us to re-vote on a specific amendment, but he is technically, artfully, craftily making a new one. So the first thing I need after I've accepted his motion is a second. Is there a second? There is a second. Is there a discussion?
24 hours, Mr. Chair.
I think Miss Oliver is urging you to vote no on this amendment so that she can get to a motion to table after we deal with the underlying motion. But the motion before us is Chairman Welch's motion. There is a second. Is there any discussion? Mr. Efstration.
Thank you, Mr. Chairman. This has been a really difficult Judiciary Committee for me because talking about flashing back in time, I'm thinking about the past 2 years and all the work and discussion and debate that's really gone into all of this. Here, I just reiterate what I've said earlier. I think my votes today reflect the fact that I'm interested in getting this right, and I'm not interested in including cases that we didn't intend to include in this court. And so all I can tell you is I at this point in time, I plan to vote for Chairman Welch's amendment for this reason. I'm going to be consistent in my position on this, that I support adding these cases to the excluded list when that issue has been debated and has really been before us. And we've had time to hear testimony as to the need to exclude these types of cases. But I have no objection to these types of cases that have been referenced here today, and that's what I was trying to communicate earlier. I just know how important it is that we move this bill forward at this point in time, and I thought an explanation of my vote that's coming was necessary. I would encourage my colleagues to vote in favor of the Welch Amendment to pass the bill with the substitute here today, and let's hold a meeting on this to go ahead and get legislation. I mean, if we need a new bill that addresses additional exclusion for business court, you have a friend in me to work on that. That is something that we want to do. We expanded the list extensively last year to ensure we didn't have unintended cases captured by the court. And the two-party consent passed by the Senate and ultimately passed by the House, I think it helped to address some of that. But if there are concerns that we miss certain areas, then let's get to work on that. Thank you.
Any other discussion? All right, committee members, the chair understands this to be the amendment in front of us, and you're happy to chime in if you think I get it wrong. Chairman Welch's motion is on line 27 to strike the word S on the end of actions and the word S on the end of petitions, and all lines that follow up to line 28, which would in effect eliminate the amendments that we previously made. Now, I see no questions. All those in favor of Chairman Welch's amendment, please indicate by raising your hand. 1, 2, 3, 4, 5. All those opposed? 2, 3, 4, 5. It's 5-5 tie. The chair votes aye. The amendment passes. Now, there's a do pass recommendation as amended, and effectively the only things that have been done to the bill is on line 27, the S after actions and the S after petitions have been removed. Is there anybody who does not understand our posture of a do pass recommendation and what the bill looks like? Hearing none, no further discussion. All those in favor of do pass motion, please indicate by raising your right hand. 3, 4, 5. All those opposed? 2, 3, 5-5 tie. The chair votes aye. The bill moves to rules. Chair needs some water. Water? Thank you. All right. Mr. Scoggins.
Yes, sir.
Judge Scoggins.
Yes, sir.
Please come forward.
Is it okay if I do it for me?
It is absolutely okay, only as long as you promise to have several parliamentary procedures that the chair has to rule on.
I got you. Thank you, members. Thank you, Mr. Chair. This is House Bill 865, which will be a code revision cleanup bill for Title 53. These changes the changes of this bill are made based on the experience of the Georgia Trust and the state attorneys and the probate judges. The General Assembly made some changes to the probate code back in 1998. The guardianship code in 2005. The trust code in 2010 and 2018. The bill was drafted by the Fiduciary Law Section, the Family Law Section, the Council of Probate Judges, representatives from the banking industry, the Attorney General's office, and of course Professor Mary Radford. In this bill, the existing law is clarified and sometimes codified for confusing and conflicted statutes. The probate judges in Article 6, courts, and non-attorney judges have their jurisdiction slightly expanded in order to move along cases in the probate court that might be slowed up because some cases needed to be transferred to Superior Courts. The changes in Title 53 will be beneficial to all parties involved, citizens and attorneys alike. Have my expert with me today, Mr. Kyle King, who is the brains behind this bill, and I'll let him make his comments. I don't think we're going through section by section today, Mr. Chairman, is that right? Or
Didn't y'all spend about 2 hours doing that in subcommittee the other day?
yesterday?
Isn't fiduciary and trust law so exciting that we should do that again?
I think it would be.
All right, now y'all start throwing things at me here in a second. Mr. King, before I recognize you, I do want to recognize we have a Superior Court judge with us today, and we also have one of our probate judges, Judge Kell with the Cobb Judicial Circuit. Judge? We also have Judge Hamrick with us. You know, I thought he looked familiar. Judge Hamrick, have you ever been to a Judiciary Committee meeting before? What a judicious response. Yeah, good to have y'all today. Thank you so much for y'all being here today. And we also has Judge Walk with Probate Court of Cobb County. Yeah, one of those small counties north of here. Yeah, good to have you with us today. All right, Mr. King, we've introduced, I think, all our judges with us today, and we appreciate them being here. Did I miss anybody?
Mr. Chairman, let's don't change this thing anymore. Julius is gonna kill me if we change it. We've changed it about 10 times.
Well, the committee is lively today and hot, so we'll see. All right, Mr. King, thank you for being here today. Please introduce yourself, and happy to hear from you.
All right, thank you, sir. I'm Kyle King. I'm here on behalf of the Fiduciary Law Section, which produced this bill, as Representative Scoggins said. I'm pleased to report, however, I am not the brains behind this. I'm one of a number of people who worked on this. As he indicated, the Fiduciary Law Section drafted this bill. It's been vetted through the Council of Probate Court Judges. We've had input from the Family Law Section, community banking associations, and all of that made its way into some version of the bill. Those of you who were here yesterday may recall that I was working from an older draft. And I've taken the time to actually go through what we have here, and I finally figured out what the change was in here. The first set of changes that Representative Scoggins had proposed that has been taken out regarded a small estate affidavit. And the reason that was removed is not that anyone thinks it's a bad idea, but that it needs some additional work on the language. And the hope is to get this moving along before crossover day, and we've committed to Representative Scoggins that we will go through the language that's been drafted and hopefully get that into shape, either to be introduced as a separate bill or to be added back into this bill at a later time. The other change, and this is the one that I have to call attention to because it did not originate with us, is on page 55. Lines 1886 to 1888, and then again lines 1898 to 1904. That is language that was incorporated in from a separate bill, House Bill 1047. That is in response to, that language would affect a case that is currently under appeal in the Court of Appeals, and we did not feel, although we responded to some case law that had been handed down that we thought did not square with legislative intent, we were very careful to avoid doing anything that would affect cases that are currently pending. There is, for instance, a case decided by the Court of Appeals last year, Peterson versus Peterson, with which a number of members of the Fiduciary Law Section disagree, but because there's a cert petition to the Supreme Court, we didn't think it was our place to step in and try and interfere with a case that was currently pending before the courts. So that language did not originate with us and is not something that we wanted included. The previous draft that we'd been working from, the LC 412373S language, that was the substitute that we were provided. That's the one that reflects changes requested by the Council of Probate Court Judges. That's the one that reflects changes requested by the Family Law Section. That's the one that reflects changes requested by the Community Bankers Association. So unfortunately, we've gotten two bills kind of mixed in together here. And we've got, Mr. Myers was kind enough to make copies of the specific section of the bill. The particular pages that are affected by those additions, we would ask to have it put back the way that it was, simply because that.
Tell me again what you've just handed to me.
What I've handed you are the relevant pages on the previous subcommittee substitute, the one that included the changes requested by the probate court judges. Those are how section 177 of the bill should appear. Again, the additional language as it appears in LC 412441S. The added language is in 1886 to 1888 and 1898 to 1904. Those are the language, the lines that were imported from House Bill 1047. Obviously, this committee can, when it takes up that bill, can choose to do what it wants to do with it. But
let me ask you this
yes,
question: if we simply removed what you've said is between lines 1886,
correct,
and somewhere in 1904, and renumbered accordingly,
I believe that is correct, and I can go through it more precisely. Although I think I've handed you my copy of the original one. But yes, sir. Thank you.
but so I mean those additions took nothing out of the bill, correct?
That is my understanding. I have not gone through it line by line, given the length of the bill, but that is what appears to be the case. We noticed yesterday that there was an accidental omission at the end. The probate judges had asked that it be given an effective date of January 1st, 2021, rather than July 1st, which we had certainly been willing to accommodate. The reason for that is some of the changes in this bill will require some of the standard probate court forms to be updated, and it's not simply a matter of them going into the template and changing the numbers. They have to go through an approval process that goes up to the Supreme Court, so it does take time. But we figured that was an easy enough fix to add back in.
So the only addition you want to make is a January 1st start, 2021.
That is correct.
Okay.
That is correct.
Because if a bill is silent, the start date is July the 1st.
Correct.
Of this year. Okay.
That is correct.
All right. So that can be simply added at the end, and I'm going to ask when we get to that point if collectively the committee will help me remember that we will do that. And let's do it this way.
Yes.
We will deal separately with the portions of the bill that you were added from House Bill 1047.
Yes, sir.
Let's deal with the rest of the bill first.
Okay. All right.
And let's get a summary of 99% of what we have in front of us.
Right.
And we'll come back and deal with that separately and see if anybody has
Fair
any
enough.
questions on the underlying matter.
All right. Thank you,
Okay.
sir. All right. As Representative Scoggins indicated, this bill does a number of things. First and foremost, it changes probate court jurisdiction slightly. It does clarify the jurisdiction in a few areas, but in particular with the non-Article 6 probate courts, those are the ones that are not required to have attorneys as probate court judges. They will be allowed to order DNA testing and to approve settlement agreements. The Article 6 probate courts will have their jurisdiction expanded to include trust matters and will construction cases in fiduciary accountings. As the law now stands, if they're dealing with an accounting and there's a will construction question, they have to transfer it to the Superior Court. Superior Court decides it, and then they send it back to the probate court. On the trust matters, there are some circuits in Georgia where the Superior Courts have a standing order whenever they get a trust case to refer it over to the probate court judge because they figure, I think correctly, that is probably the best place for it. So we have look to expand the jurisdictions of those courts, be able to have them heard in the courts that are best equipped to deal with them, and hopefully lighten up the Superior Court dockets at least a little bit. Probate court procedure, we've attempted to change in response to some recent appellate court decisions that appear contrary to legislative intent. We've tried to make the terminology more consistent. For instance, there are code sections that still refer to guardians of the person and guardians of the property, even though that hasn't really been the language that's used in the last 15 years. We're trying to clarify the requirements for serving notice of a probate proceeding and for filing creditors' claims. And finally, to restore the finality of solemn form probate. As you may know, after a case that the Court of Appeals decided last year, solemn form probate currently is not as binding as common form probate. There was a situation where a stepson of the deceased, someone who was not an heir, and did not receive notice, filed a petition to set aside a probated will because he had not received notice, and he had what he claimed was a prior will that was entitled to be given consideration. And because of that, there's really a very open-ended ability of someone who is not an heir, who is not entitled to notice, to come back sometime after the fact and try and set that aside. So we're trying to limit that so that people can get the finality that solemn form probate has always been understood to provide. Also, the time for filing objections in the probate court is being expanded from 10 days to 30 days. Obviously, in pretty much every civil context in Georgia, 30 days is what you get. We're hopeful that this will allow time to settle some disputes before they actually have to come to actual litigation, but at the very least will allow reasonable time for people to seek the advice of counsel. I recognize, as Representative Kelly said yesterday, this probably means a lot of folks who waited till day 8 or 9 will instead wait till day 26 or 27, but should at least allow some opportunity to respond as you would in any other civil action.
Mr. King, the
Yes,
chair
sir.
is trying to decide if he wants to take questions on each part that you're discussing or take
Okay.
questions at the end. So how many parts do you have to discuss with us going forward?
There are about, counting the couple I've gone over, probably 5 or 6.
All right, okay, I was fearing you were gonna say 20-something.
No.
So,
No, sir.
Let's go ahead and talk about the 5 or 6 major parts, and then committee members make notes, and we'll come back to whichever portions you have questions about. Go ahead, Mr. King.
Thank you, sir. Regarding the right of years support, as many of you know, the years support has been a long-established Georgia procedure unique to Georgia for making sure that we are protecting the rights of surviving spouses and minor children.
What section you're in?
I apologize. I'm sort of giving, in an effort to give an overview, talking
not
about
dealing
things
with it
broadly.
section by section.
It would be multiple sections, and unfortunately they're not. Because the bill is arranged in numerical order, they're not all clumped together.
But Mr. Reeves, we will go back and discuss any section that you want to discuss.
I will say that
He's giving us an overview right now. Go ahead, Mr. King.
Typically, the year support is going to be in 53.3. So it would begin with section 1.5, and the following sections would be where most of it is located. With regard to the year support, we've made efforts to safeguard the deposits, the small accounts of deceased depositors, to make it clear that inferior debts are being subordinated to the year support, protecting divestment of property taxes. Again, as you may know, whenever real property is set aside in a year support proceeding, one of the ways of dealing with the financial hardship of the loss of a provider is that you can get a year's worth of property taxes taken off. Unfortunately, sometimes these petitions are filed, and between the time they're filed and the time they're granted, there are occasions where, particularly if you have a mortgage company that's escrowing taxes, the property taxes for that year will be paid. And there are some tax commissioners who take the view that if that year's property taxes were taken off, but you paid them anyway, oh well, too bad. You made a voluntary contribution. So what the bill would do is simply state that if they're paid in between the filing of the petition and the granting of the petition, it would simply roll over that year's worth of property taxes to the following year, so that you get the benefit of that. And in general, again, that's designed just to protect the financial hardship, protect against the financial hardship that unfortunately accompanies all too often the death of a loved one. Regarding last wills and testaments, we've codified longstanding common law regarding incorporating existing documents by reference. Many of you who draft wills may be familiar with the fact that many people will want to provide a separate written memorandum for dealing with heirlooms, keepsake items. This would give some standing. It's not, no.
Because I always tell my clients that it is in the law when I do that.
Well, and what most wills say is that I may leave a list just to deal with the sentimental value items.
Yeah, that's in all my wills, but I
Right.
say Georgia law lets you do it, but actually it doesn't.
Well, it doesn't say you can. It doesn't say you can't.
I think legislative immunity would resolve any
believe so,
problems
yes,
that he's
yes.
created because it was legislative speech that he just uttered.
Yes.
But you go ahead, Mr. King.
No, that's quite all right. But yes, a lot of people do that and expect their executors to rely on them. I'm sure that in many cases they do, but certainly we want to give some teeth to that when people use those. Also, we wanted to make certain that the will execution formalities are clarified to ensure that electronic presence, which is sufficient for some signatures, would not be sufficient in the case of a will execution. And finally, there's a language added to clarify what does not constitute a violation of a no contest clause. Again, this is codifying what we understand the existing law to be, not changing any of the legal standards. On the trust code, of course, in 2018, there were significant revisions to the trust code. After a year and a half of practical experience with them, we're clarifying and expanding those provisions regarding virtual representation, non-judicial settlement agreements, trust modifications, trust decanting, and trust directors. Particularly with trust directors, are ensuring that when you divide up the authority of a trustee and a trust director, we want to make it very clear that someone in that situation always has to have fiduciary duties that they owe. Someone has got the liability if they fail to do their duty. And you can divide that up, but you can't absolve it completely. And also, with regard to the trust code, clarifying what does and does not constitute a violation of a no contest clause in a trust instrument. And then finally, just miscellaneous provisions. There are amendments to the Georgia Power of Attorney Act to bring those Uniform Act provisions into line with pre-existing statutes regarding real property transfers and Medicaid trusts. There's an amendment to Title 15. That would be, hang on just a second, it would be in Title 10, so that would be toward the back of the bill. Give me just a minute. Actually, maybe. Let's see. Yeah, it would be
Line 3243.
Thank you very much.
Or 45, rather, maybe.
That's right. We've got carrying over onto the following page there, lines 3261 to 3266 is dealing with what we used to call transaction-specific powers of attorney to deal with things like if you had a power of attorney for one single real estate transaction. And the broker-dealer is dealing with stock transfer powers. Then below that in Section 211, Professor Radford pointed this out to us that in some of the changes that were made, it could be read to indicate that the ability to use a power of attorney to set up a Medicaid protection trust had inadvertently been omitted. And to make sure that agents have that authority, we're clarifying that and putting it back in to make sure that people can still establish Medicaid trusts on behalf of their principal.
Okay. Mr. King, I appreciate that overview. I think
Thank
you were
you.
about to stop, correct?
That's it. That's
Okay.
it. We're good.
Mr. Wilson, I think you pressed your button in the middle, and I told you to hold that to the end, so we'll let you go first. Mr. Wilson?
Thank you, Mr. Chairman. Mr. King, thank you very much for going through that, and in particular for the 2-hour subcommittee hearing.
Quite all right. Was happy to do it.
I appreciate that.
I thought it must have been a big hit if y'all asked me back one day later. Okay, we've been extended engagement here. So.
One of the in reviewing all of that and going through all of that section by section yesterday, like we did, I believe that was yesterday.
It was. Yes.
One of the things that jumped out to me the most, which I if you will spend 30 seconds or a minute discussing it, Section 2-2 starting at line 3011. Please.
What line, Mr. Wilson?
3011
Yes.
on page 86 of our copy.
Sure. And this is a change. This is in response to a change that was made last year. Previously, the way the law was structured, the family could go for a deceased depositor who did not leave a will. The family could, within 90 days, go to the bank and withdraw up to $10,000 to deal with a small estate situation. That figure's now been increased to $15,000, which we're fine with that. The problem was, at the same time, the time frame was reduced from 90 days to 45. And after that 45 days, funeral home providers, funeral services providers, and medical services providers can fill out an affidavit, file it with the bank, and get up to that same $15,000. The concern was, first of all, that the affidavit that has to be filled out has to certify under oath that there's no one who falls in the category of the next of kin. There's no spouse, there's no children, grandchildren, siblings, parents, which I think is very unlikely that a funeral provider is going to know, but let's assume that they do. They help prepare the obituary. They know who the next of kin are. They also have to swear under oath that the decedent died without a will, which, again, it's fairly inconceivable that that would ever be known. And the problem with the 45 days is that, first of all, it's highly unlikely that a probate proceeding is going to be commenced, much less concluded within that time. And then, in addition, the difficulty, as I discussed yesterday, just from the standpoint of being a responsible attorney and also being a decent human being, I will frequently get calls from people on a Monday morning informing me that their father or their mother has passed away over the weekend, and they ask what they need to do. And my advice to them is to go bury their parent, go be with their family, go take the time to grieve, and then in a couple of weeks or a month when they are up to it, then give me a call. There's no rush. And with this 45-day clock ticking, I have to ask them a few questions before I tell them, the good, right, decent thing to do, because I don't want to disadvantage them and have this money taken out. And again, it's no disrespect to funeral services providers. They provide a service and they ought to get paid. But they're already, under law, the highest priority creditor of an estate. They're going to get paid before tax liens. They're going to get paid before medical bills. They're going to get paid before the lawyers do. So they're in a pretty good position.
Hold on a second. What?
That's what I'm saying.
Okay.
So
well, the funeral home caucus should be happy with us.
So there's an issue with that time frame, and really what this is designed to do. We're not trying to put any new liability on banks. We're just trying to get the banks to pump the brakes a little bit and trying to give them the cover that allows them to delay dispersing that money, or to require that someone go initiate a probate court proceeding and bring a court order to them, and let them know that's okay. If they want to take their time, we're all in favor of that. People will get paid, but we want to make sure that people are not being taken advantage of.
And Mr. Chairman,
Sure.
just to
And
be
I
clear,
know Judge Scoggin wants to weigh in on this too, but you go ahead and finish.
and just to be clear, I want to make sure. So what the change does is it allows them to delay it now up to 180 days?
Correct. And 180 days is based on the fact that an executor has 6 months before they have to start paying claims, and that would allow the same 6 months.
Judge?
This will all be addressed in the small estate affidavit that we pulled out of this bill. This will all be addressed in that small estate affidavit, and we don't have to worry about the 180 days once we get that incorporated in the law.
Okay.
Right.
Mr. Wilson, any other questions about that one? Ms. Oliver, you had a question?
I was interested in page 54, lines 1848. Is these limitations on interim clauses, is that case law, or did y'all make that up last year?
No, that's case law. They're case law that says all of that. The entering into a settlement agreement part, That was raised by Representative Efstration, I believe, last session, because a constituent of his had raised the question whether agreeing to a settlement agreement that deviated from the language of a will or a trust, did that violate it? And our view was that it was not, because if everyone is consenting to vary the terms of the instrument, then as part of that, you're agreeing that you're not going to disinherit one another. But out of an abundance of caution, because he'd raised a legitimate point, that was put in there to clarify it. As you know, the appellate courts are being very, very particular about precise language, and so our thought was anything that is the common understanding of what the law says, it's a good idea to go ahead and write that down to make sure that no one thinks that suddenly it's not there anymore.
Thank you.
Okay, other questions from members of the committee for Mr. King? Mr. King, you evidently have, well, in my opinion, done a very good job and very versed in this. But you can't come on the floor of the House with.
No, I understand.
Judge
I
Scoggins.
understand.
This dawned on me. You're quite an asset there. Mr. Reeves?
Thank you. Are you going to teach the CLE on this?
I'll be more than happy to do that. Yes. Yes.
I play in Title 53, and
Sure.
I wasn't in the subcommittee yesterday, so I'm going to need a CLE.
Okay. Understood. Understood. Thank you.
All right, any other questions? Now, I do want to go back. You had another question, Ms. Oliver? Well, I want to go back and deal with the issue that he brought up about a portion being inserted from another bill. The chair said he would do that afterwards. So, page 55, and tell me the lines again, Mr. King. I know it starts at 1886.
1886. Yes, sir.
1904, I think.
To
Yes,
1904.
It's two sections there.
But everything in between 1886 and 1904.
All of them are in that area. The first part is beginning at 1886, going to 1888. All of the underlined language from numeral 1 through the
C1.
C1, correct. C is there already. But 1
I got you.
through on 1888, where it's following with a lowercase f, and then the strike through of following with a capital F. We would remove everything that is underlined and remove the strike through so that it would read C, following the settlor's death, the court shall approve.
Okay, let's talk about the merits of this portion.
Okay.
This is House Bill 1047, introduced by Representative Hatchett. He told me he had a trust matter, and I told him we had a big trust bill coming through, and that we could bring that to the subcommittee and allow them to discuss it. And the miscommunication may have been my fault, but the subcommittee chairman couldn't be here today because he had a funeral that he had to go to. But it was my understanding that the whole portion went through, and that y'all were okay with that.
And I apologize.
Yeah.
We received this yesterday,
Right.
And we're going through it, and again, we're going section by section, but not line by line, and frankly, didn't have the opportunity to sit down and compare them side by side, and it was only in going through it and seeing that the line numbers didn't line up. So we inadvertently missed that yesterday, and that's on us.
So a couple of things. I'm about to get to that. So a couple of things that I want to discuss. First of all, I want to discuss two things. You mentioned that it would affect an ongoing case on appeal. I want to discuss that point.
Correct.
But before that, I'd like to discuss the substance of what it actually does.
Right.
You want to give us a shot at that?
Sure. Well, what this section C1 would do is that it is defining irrevocable trust for purposes of this particular subsection. One of the, again, in an effort to be comprehensive in this bill, we have clarified the definition of what it means to be a charitable trust. So for one thing, I think there would be some conflict with this and the other aspects of the bill that deal with charitable trusts. And then on line 1888, the paragraph 2, except as provided for, that's creating an exception under those later lines, 1898 to 1904, that does not currently exist. And what that modification, that exception would do is it would require that any time there is a change to a trust, a modification being made that would affect certain aspects of the trustee's role, that the trustees' approval would be required. Now, we already have language regarding changes in trustee compensation. We already have language regarding increasing trustee liability, that those things can't be done without the trustees' involvement. What this would do is it would address the trustees' consent to an amendment that would allow the removal of a trustee. And there are, of course, a number of problems with that. Number one, again, we do think that there are specific instances where it would create an issue. But also the fact that trustees inherently have fiduciary duties that they owe to all of the beneficiaries. If a trustee's consent to modify a trust is required, it means that they are going to have to be mindful of the rights of all beneficiaries. It's going to be very difficult ever to get a modification approved under those circumstances. It's one thing if this set of beneficiaries over here with these interests agrees with this set of beneficiaries over there with those interests, and they can work something out amongst themselves in what each of them considers in their own best interests. The trustee is going to have a difficult time splitting that baby unless there's specific language in the trust that authorizes them to do so, because the law would require them to give equal consideration to income and remainder beneficiaries. They're going to have a tough time doing that when we're dealing with, in many cases, dynasty trusts that are going to go on for generations, and they're having to think down the line to great-great-grandchildren who have not been born yet, and whether they can ever consent to those sorts of modifications is going to make it very difficult. And frankly, I know I don't want to be advising a trustee who's the holdup as to whether they can or cannot agree to a modification that all the current beneficiaries are agreed to.
So let me ask you this question. All right, that's the substance of that, and I want to ask our probate court judge if they have any comment that she wants to make on that. Not yet, but just you think about it, I'll come back to you in just a second. The other thing that I want to touch on very quickly, and maybe we can dispose of that more easily. You said, yeah, thank you so much. You said that this is a substantive law change, correct?
Correct. Yes.
And there's a case on appeal now, and you thought it would affect that.
That's correct.
Why would it affect that if this is substantive law? Would not the substantive law at the time the case was brought be the law that rules, that is determinative, not a substantive law change that we may make that will become effective January the 1st? And I say that because it's always been our position on this committee that when we make procedural law changes, that may affect an ongoing matter. But substantive law issues, the cases are judged of what the law was when the case was filed.
And that very possibly is the case. Our concern is simply the idea that if there is a case on appeal, if there are litigants having this argument right now, we don't want to be responsible for coming to you because we are very conscientiously not a political organization.
Well, you got that part down. You're on record for that.
And
if we made this change, it would be us, not you.
No, I understand.
Yeah. No, but I appreciate your point.
The point is that if the law were to change in mid-litigation, even if it doesn't change the outcome, even if it doesn't affect the substantive law on which that's decided, it does mean that one of the litigants now gets to go before the appellate court and say, Your Honors, the legislature obviously thinks we're in the right because they've changed the law. This is not what the law will be 6 months from now. Why should it affect our case?
We're okay with that part.
Okay.
Yeah, at least I am, because we do that quite often here. We send signals.
I understand.
Yeah, we did, but it would be ruled on according to that. That's a different issue, and I think we're clear on that one.
Correct.
So,
and again, my
suggestion
is that
what the merits
possibly has to do with
right.
I don't know who wrote this. I don't know who came up with this idea.
So hold on a second. Let the chair begin to address this. So Chairman Hatchett brought this bill on behalf of someone that contacted him. He had an attorney with him yesterday. Should y'all have had any problem with this, so that attorney could explain and defend that position? That attorney is not here today because everything went fine yesterday with this. And so Chairman Hatchett is now at a significant disadvantage. He doesn't have his lawyer with him. Shall the chair appoint someone in the audience? I'm just kidding. I'm just kidding.
And
I know these things happen. It was not intentional, and
Right.
it was an oversight. But that's the place we find ourselves now. Judge, did you want to? I didn't know if you were signaling to me that you had something you wanted to add to that.
Well, I just feel it's in the right place, and I think it's good law myself. I mean, that's me looking at it. I think it's good law, and I think it should be left in this bill.
Now, Miss Oliver, I'm sorry. I was trying to get out some points to help with our conversation. You go ahead.
And forgive me, I'm behind here, but I can't figure out what it in this keeps referring to. Is there a document somewhere that relates to some bill that Representative Hatchett wants to introduce somewhere in this bill?
Yeah.
Is there a document I could look at, maybe explain?
It's the same bill.
That's okay.
And if I may add, Mr. Chairman, I understand, I appreciate the fact that he is at maybe a disadvantage today. We were at a disadvantage yesterday. I came here with
I understand.
with a
I'm
committee
not
substitute I had
fussing
not,
at you.
seen.
I'm not fussing at you. It's the first time any mistakes ever happened in this committee. It's a shock. I'm being facetious now. This happens to us regularly, particularly toward the end.
I haven't read this. Is this what the bill was that Representative Hatchett wanted?
Yes.
This document here?
That's what his attorney brought with us yesterday, and it was for discussion purposes in case there were any problems with it.
Okay, I'm catching up here.
Mr. Welch, you want to comment while Ms. Oliver's looking over that?
So just explain to me exactly what do you think this language will do substantively?
Substantively, it means that anytime, right now, if a trust modification action is filed and all of the beneficiaries consent and the trustee gets notice, the Superior Court, or in the future, the Probate Court, can rule on whether that modification is appropriate and allow it. If this change is made, it would require that anything that affects the trustee would have to also receive the approval of the trustee. And again,
approval or notice?
I believe it says approval, is my understanding. Yeah, without the trustee's consent thereto. They're already entitled to notice. That's in the law already. And parts of this dealing with increasing duties or liabilities, that's already in the law. Decreasing the compensation, that was inadvertently left out in one of the 2018 changes, but that's being corrected in this bill. So the only substantive change that it effectuates is that it otherwise affects the rights or obligations of the trustee under the trust instrument. And again, the specific situation that is currently before the appellate courts has to deal with trustees who were removed and who are now seeking to challenge their removal in their issues of standing with their ability to do so.
And if I may
yes.
ask a question about it, my understanding when I was trying to be explained this was that the problem was that the trustees had no notice that there was going to be a judge considering an order to remove them. And that's why on line 1900, obligations of the trustee under the trust instrument without the trustee's consent thereto, which is what you said, or upon a hearing with good cause shown.
Sure.
That's the whole thing in the appeal is the good cause was not shown and the trustee was not notified.
The trustee didn't even know that they were going to be removed from the trust, and the ideal was to require that they have notice in a hearing.
And I'm not involved in that case.
Right.
I have a different understanding of whether they receive notice, and certainly what the law currently says is on any of these, the trustee has to have notice. So if the concern is trustees not being notified, maybe in that case they weren't given notice, and if so, they may have grounds to overturn this on that basis without needing the law changed. But the issue of
but this
of
is
notices,
not. But the trustee's consent is not a veto of their removal because of the word "or" upon good cause shown with a hearing. A judge can still do that.
Understood.
All right,
Understood.
and I thought may have misheard you, but I thought I got an impression when you first spoke that we were changing the laws where the trustees could not be removed, but that's not the case.
No,
They can be removed.
They can
They
be
just have to
removed.
have a hearing opportunity for hearing.
that is what this would do.
Right.
And right now, they have to get notice of that change. There's not necessarily a requirement of a hearing.
After they've been removed. So my point, the point is, I understood this. What it seems fair if your trustees for a trust, and
Right.
someone is going to remove you, that you have the ability to be notified to come to the hearing to defend yourself. And if a judge doesn't buy it, he can remove you. But what happened in this case was they didn't even have notice that a judge was going to sign an order to remove them. And what we're just simply saying here is that, yes, if the trustees consent, they can be taken off. But if they don't consent, then you have to have a hearing. And that requirement of a hearing means that they get to come and be heard. Now, that is my understanding of what the intent of this was to do. And I'm willing to be corrected if I'm wrong on that, but I think you agree with me on that is what it would effectively do.
It would, but again, the law currently provides for them to receive notice of that. If there's a separate
Of being
notice
removed, but
of-
not a notice of a hearing to remove them.
Well, it's
Am I
actually
wrong?
there are actually two separate code sections that are affected on this. The one that's actually being changed, that is proposed to be changed, is the one that deals with notice of a modification petition. The particular case,
i.e. a petition to remove the trustees.
no,
Okay.
a petition
Correct me.
to what the specific situation that you're talking about was there was a petition to modify the trust in a way that would then allow the beneficiaries to substitute trustees, and they then separately did that.
Sound like
The
a good
modification.
lawyer.
Sounds like my amendment.
Right. The modification action, they do have to get notice. The trustee has to get notice. Again, if they didn't get it here, then that is a reason for overturning it, never minding the substantive issue. The separate proceeding, and I believe it's 5312 201 or 221, I apologize, but there is a specific provision that deals with a separate petition to remove a trustee. So we're dealing with two different things. If you want to file a petition to have a trustee removed, yes, you have to file that petition and the trustee has to be served and they'll have the opportunity to be heard. On this, we're dealing with a petition to modify a trust. It could include the ability to then take that extra step, but they would just have to get notice.
So what this is doing is closing the back door.
Yeah. So what you had in that case was that they accomplished not notifying the trustees by changing the underlying rules, so to speak, of the trust, so that they could be removed by action of the beneficiaries.
Well, again, they did still have to receive notice of the modification. I agree with you that they then were not required to file a separate action for removal.
Yeah, okay. Now, here's the chair's position on this. I think I understand what this does, and I'm okay with it. However, I'm going to let the committee obviously make that decision if they want to leave this portion in. And am willing to hear from anyone who wants to argue against that, because I do want us to do the right thing here. And I guess you would say my request, so to speak, when I agreed to allow this to be included, was it to be heard in subcommittee, and that if there were problems with it, that we would not include it. And unfortunately, and it was not your fault, I'm not saying that it was a miscommunication possibly between me and the chair of the subcommittee, but he understood that it was discussed and there was no problems. And with it being a sub, I could see how there could have been some mix-up there, and y'all had a chance to look at it closer. Right. And I think what you're telling me is that you'd rather not have it in here because it's not something y'all proposed.
Well, that is correct, but when I say not something we proposed, we're not pride of authorship. It's just that we had the opportunity to go through the process of vetting it, drafting it, running it by the Council of Probate Court Judges, the other interested stakeholders, and getting feedback to make sure that we weren't doing something inadvertently that didn't have proper discussion.
Understood. And if we could only have that process for y'all for all the other bills that we pass around there.
I understand. I understand.
But it was introduced as a separate bill, and it was me that gave the green light to put it in if it was okay, and that's what the committee will decide today. So
Y'all have done a great job.
Thank you.
and you have done an excellent job. The bar and the different subsections of the bar always are excellent, particularly the probate judges, because I've carried their bills before and things that affect them. Mr. Sewell, did you want to make a comment?
Yeah,
Come on up and introduce yourself.
State Bar. And Kyle is saying the right things because that's what he's supposed to do when the section has gone through. It's one of these things, we try to stay away from that, but that's not y'all's purview. Y'all can do what you feel because we don't want to come into that. And if y'all go forward with it, which seems to be there maybe is something there to do or consider, we're going to continue to work on it as it goes through. We got a long process, and you know, this kind of bigger bill, and we got to go to see Jesse Stone, and Jesse on these kind of light bills, he likes to go through too, just like y'all do. And you know, we'll be happy to work on it and see if there is a better. I understand what you're coming from about the notice, and we want to make sure that we satisfy you in that regard. But,
Thank you.
Yeah,
Appreciate
we
that.
don't like to put anything in. You would
And you
yell
can
at
claim
us
you
if we
didn't. We
that.
did it to you, so.
Well,
Yeah.
Don't worry, I will.
And I'll sign an affidavit to that effect.
Yeah.
Okay, all right. So any other questions, Ms. Oliver or Mr. Wilson or Judge or anybody on that section? Because the next thing I want to move to is an amendment to add the date that they want, unless there are other questions regarding the bill. Ms. Oliver, did you have anything else? Okay. All right, so hearing no, do we have anybody else signed up to testify? That's it, okay. So we need to add an effective date, Mr. Talbert, of January the 1st, 2021 by the probate judge in the fiduciary section of the bar's request. I think we would add that, would we not, in between line 3806 and 3807? Help me out there. Do you want to us just tell you to do that and you put it in there later? Is that easier for you? Okay. So the motion is for Mr. Talbert to put an effective date of January the 1st. Let's back up one second. Is there a due pass recommendation? Ms. Oliver moves due pass, second by Mr. Welch and Mr. Wilson. Madam, Ms. Oliver.
To add an effective date of January 1st, 2021.
And Mr. Talbot will effectuate that for us. Okay, there's a motion by Ms. Oliver, a second by Mr. Wilson. Any discussion? Hearing none, all those in favor say aye.
Aye.
Now we are back to the underlying bill by subcommittee substitute as amended. Any discussion? Hearing none, all those in favor of due pass as amended by committee substitute, please indicate by saying aye. Aye. Any opposed? Judge Goggins, you're off the rules. Thank you. Thank you so much. We will
Thank you
stand
very
adjourned,
much.
and we will likely have, committee members, we will likely have another hearing tomorrow, another full committee hearing tomorrow. Okay?